Good morning. My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is February 6th, 2025, and this is case DCI 2024-00029. It's a rezoning request to the CPD zoning district along Daniels Parkway. Because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
Yes, ma'am.
Thank you. And I think, do we have a member of the public here today? Thank you. Are you familiar with our process? Has someone explained that to you? Okay, thank you. Then I'll dispense with those instructions. We can begin with the applicant whenever you're ready.
Okay, thank you.
Good morning.
Good morning. For the record, Tina Ekblad, principal at Sage Entitlements. I do have a couple of housekeeping items before we get started. I have full copies of the PowerPoint for the hearing examiner. Did you want to label that as Exhibit 1 or?
What else do you have for me? And we'll go through.
I also have a copy of the conditions that we attached to the 48-hour letter, and I have copies of my resume as well as Paul's for the record.
Okay. Yes, I think I have all of those in the 48-hour letter, which was pre-labeled applicant A, but I'll take them individually aside from the PowerPoint.
Okay. So
the PowerPoint would be applicant 1, as you said. Thank you.
So I've got one for you to write on, and
Okay.
then one for the record.
Excellent. Thank you.
And then I've got a hard one for Sean.
Thank you.
And then these were the conditions.
Okay.
Did you want two of that?
Are they, just one is fine. These are identical to what I had in the 48-hour. Okay.
Yeah.
Yes.
And then I've got resumes. That's mine. That's Paul's.
Okay. Thank you.
And I forgot, we also have the full TIS for you as well. That would be more like a composite exhibit. We have the original submittal and then the insufficiency response.
Okay. And are those identical to what was in the staff report and in the 48-hour letter? Okay.
Yes.
Thank you. So I will take that. Let me get these in order as I go through. All right. So applicant's exhibit A was the 48-hour letter, which included these items, but I'll separate them out just for housekeeping purposes. Then applicant 1 is the PowerPoint presentation. Applicant 2 would be Ms. Ekblad's resume. And then applicant's exhibit 3 would be Mr. Marcino's.
Marcinko.
Thank you.
Thank you.
That would be your resume, sir. And then applicant exhibit 4 is the composite TIS with supplemental memo. Okay. Oh, and I apologize, I missed the condition. That would make the conditions applicant 5. Okay, I'm ready whenever you are.
Okay. Also for housekeeping on the record, Tina Ekblad, I am a certified planner, and I have been accepted as an expert in land use planning previously, and I would request to be accepted so today.
Yes, and the resume that you provided was just updated. We already had one on file, so this is intended to replace that?
Correct.
Okay, thank you.
Yes. So we're here today regarding DCI 2024-00029, which is for a DollarTree that on Daniels Parkway. We do have our full project team here today. Delaney Property Group is the applicant and also the contract purchaser of the lot. Ms. Montgomery is here from Pkwy Law Firm, myself, Mr. Treesh from TR Transportation, and then Mr. Marcinko from Jade Consulting is our civil engineer. So I thought I would just start with where we are in the world. This lot is part of an existing subdivision that is located south and east of the city of Fort Myers. So if you can see the dashed line on the aerial here, that is the city limits, and our parcel is in this location here. We are west of the JetBlue Stadium and then across Daniels Parkway from the airport. We are here today because the lot actually has split zoning. Currently, the western portion is within the CT zoning district, and the eastern portion is within CG. Because of our Tradeport future land use, we had to come forward with a commercial plan development in order to be able to develop the property for commercial uses. The plat establishing the lot was recorded in 1991. And for the record, I'll just give you the name of that. It was Southwest Regional Commerce and Trade Park. And what we are asking for today is to establish a series of commercial uses and a 10,000 square foot building on this lot of standalone retail. You'll notice the master concept plan references an access road. That access road is actually being permitted under a different development order as a result of this parcel to our east. So there will be access from Rickenbacker to Daniels Parkway through this lot that's in front of you today for the CPD, but it's under the development order for the parcel to the east.
And is that under review right now, the development order?
It's actually been approved, is my understanding.
And that's for the 7-Eleven that was referenced in the materials? Okay.
Yes.
How'd you know that?
It was in the materials about 1,800 times. And I did the site visit. I didn't see anything that was happening on the site. So I've got a lot of questions about the access road and how that's going to go, but I won't stop you now. Yes.
Okay. So then, moving on, for the record, we did want to kind of work through the details of the plat and how that relates back to the trade port future land use and the standalone commercial calculations. So as I mentioned, this commercial subdivision was platted in 1991. In total, it was 74 acres. There are 2 existing preservation tracts that are just under 28 acres, and those are on the west side here. There is a small piece of wetlands that shows in our master concept plan but is not part of the lot. And then along the northeast quadrant here, those tracts are those existing wetlands. As part of that subdivision, there was 1 acre of wetland impacts to allow Rickenbacker Parkway to go from Daniels into the back to these industrial uses along the northern boundary of the plat. So actually, I'll stick with the existing development for just a second. Generally speaking, a majority of the platted lots have been developed, most of them with industrial uses consistent with the trade port future land use. There are existing commercial activities occurring along Daniels Parkway to the east of Rickenbacker Parkway. There's a Norman Love here and then like a small strip commercial center here. To the west, as you mentioned, there is a 7-Eleven that is approved via development order at the northwest corner of the intersection of Rickenbacker and Daniels, and then our lot here is proposed to be the 10,000 square foot DollarTree. So when we look at the trade port future land use, it does allow commercial uses, but there is a limitation on standalone retail, every 1 acre to every 10 of trade port and preserved wetlands. So when we look at the whole subdivision, we had 74 acres. With that 1 acre of wetland impacts, we're down to 73 acres. Using the calculation in the trade port future land use, that gives 7.3 acres of total standalone commercial development is permitted within this subdivision. As I mentioned, there is existing commercial retail along the west side of Rickenbacker Parkway, and that leaves 3.8 acres of commercial retail available. Our property is 1.8. So there is adequate square footage for the remaining 2 parcels to have standalone retail on them consistent with the future land use category.
Okay, so even that, when you refer to that entirety of the area of the 73 acres, it's platted, but it wasn't under a PD or any kind of unified zoning currently.
That's correct. And if we go back, you can actually see that the zoning within the subdivision is a variety. So we have some small plan developments in the industrial quadrant. We have conventional industrial zoning and then even some ag within the conservation areas.
And are the conservation areas, they're platted, you said, but are they also under an easement or are they to some, what is the mechanism, I guess, if there isn't an overarching PD, what ties them to ensure that those remain preservation lands to pull out the commercial acreage that you're getting?
I don't know the answer to that. I can certainly look into whether or not there's an HOA or a conservation easement or something of that nature.
It was referenced in the materials in your narrative. It talked about a 2011 county memo that basically sanctioned this, but it wasn't in the materials. So it's just, it's a curious configuration because you do have various zoning districts on this area, but it sounded like there had been a determination made previously that you were unable to do this with this calculation, but I didn't see that in what I have.
Thanks to Paul being overly prepared, I do have a copy of that memo if you'd like it.
Yes.
Okay.
Please, that would be helpful. Does it address that question?
It doesn't address the preservation areas, but it
Thank
works
you.
through the calculations and how the whole subdivision was considered and that there's adequate land area left. And I would say perhaps we could, for either a break or if we leave the record open, we could look into if there's a recorded easement or something.
Okay, that would be helpful. Thank you for having it. This would be applicant 6, by the way, but thank you for.
Yeah, and we didn't drill down further, but even Norman Love, having been to classes there, has industrial, you have the storefront in the front, but the back of it is production and industrial. And there are office buildings, you got the fine folk pizza, but then you've got medical office and some other kinds of technical offices in that plaza. So, I mean, if you really had to drill down, it's not, the whole 3.78 isn't all retail.
Thank you.
Okay, so maybe.
Shram, is it?
Oh, it's not working?
Nope.
Can you make it go?
Do you mind going to slide 7? Can you make it? Yeah, there you go. Back one.
Back one?
There you go. Were there any other questions about the trade port and the standalone commercial or?
Not at this time.
Okay. Okay. So then from the perspective of urban services, this property is in an area that has access to all of the urban services. We did get a letter of availability from Lee County Utilities. Station 64 of the South Trail Fire District does have emergency services. And then the main headquarters on 6 Mile for Lee County Sheriff would support this property. Can you go to the next slide, Sharon? So from the perspective of the master concept plan and what the proposal is, we have a 10,000 square foot commercial building in the northwest corner. We are consistent with the approved ERP, preserving existing wetlands on site adjacent to that platted conservation area I talked about in the other slide. We're providing the full required suite of buffers, parking. There is pedestrian interconnectivity along the eastern side of the property so that there can be flow between the 7-Eleven and this future development here. We did request one deviation associated with the dry retention area in this location, and that was to reduce the setback from the property boundary to 25 feet. By code, 50 feet is required, but you can ask to go down to 25 feet. We felt that that was appropriate given that it's for dry detention and the adjacent property is Lee County preservation land. And so there shouldn't be any pedestrian connectivity or any issues with the public in that location. There are no other deviations requested, but this would be a good time for me to kind of explain the revisions to the conditions that we're asking for. So I did speak with Shrum this morning, and he does not have any objections to the changes to the site development regulations. This project is considered a small project. It's less than 2 acres of impervious. And so as a result, the minimum open space is 20%. So we're proposing to change the 30 down to 20 to be consistent with the land development code. The master concept plan does include an acreage regarding the open space that's consistent with the 20% in the notes. So that's just kind of clean up there. And then with regard to the minimum lot area and dimensions, we are requesting the area width and depth that is proposed with this CPD to be the same as the district. That way, in case there's an issue at some point in time with the DollarTree, we could come back and do some reconfiguration if necessary through an administrative amendment or something else, rather than it being, the full 1.8 acres. And then just for housekeeping, while we're on the conditions, we did propose to eliminate the condition regarding transportation because it's a duplication of an existing ordinance.
Do you have a copy of that resolution? I couldn't find it. I was just going to take judicial notice of it since it wasn't, and I was able to locate 210906 that I think incorporates by reference 210506, but I didn't know which one you wanted in the record.
They also just adopted a new one on Monday, so would it be appropriate to reference that one instead?
Okay.
Yeah.
Okay.
Okay, Ted's gonna cover that. Shram, can you go to slide 11?
Actually, can you stop for one?
Oh, sure.
The buffers, was that all you were going to say about that? Because I had one question.
Yes, happy to work through that.
There was a note in the I think it was in the environmental memo that said that a type A was required on the east and west, and that both were shown on the MCP, but the MCP shows that there's no buffer required on the west side. So I just wanted to clarify that. Yes, it's in attachment F of the staff review. They say the west property line abuts an undeveloped CT zoned lot and a type A buffer is required and shown on the MCP, but I didn't see that.
So the type A notation on the east side is up in the northeast corner here.
The east side I saw, but the west side is what I'm looking at.
Oh, okay, sorry. You're right, the hatch mark is there and the text is not. So there's a,
The table also says west side none required on the site data table, so it may just be revisions that we need to make
Okay.
to the master concept plan, just to be consistent. It's preservation, it looked like, from what I saw, it was preservation area, so maybe that's why they weren't thinking it was required, but then the note said that it was shown and I didn't see it, and I actually saw the opposite, so I just want to be consistent.
yeah, I was just gonna say, if the use is preservation, then do we need, I don't think a buffer is required.
I don't know if it is or not, I just want to be, again, consistent. It looked like staff saw one there, and it's a question I can ask Sharam as well, but again, just for consistency's sake, I wanted to get clarification on that.
Okay, I'll pull the LDC while Ted's talking and see if we can't get an answer to that.
Thank you.
Okay, any other MCP questions?
The only other one, you mentioned it, they talked about on the north side that a portion of it abutted the preservation area, so they would have to require a type F buffer, which also, I don't even know where that is on this side. I don't think it even matters because you've got such preservation lands there.
Correct.
Do you know what the depth of that might be approximately?
I don't. Do you happen to know, Paul?
The depth at the corner?
Of
Yeah.
that preservation area?
The preserved wetlands.
I don't have that number. That line that's represented there is based on the permitted fill from the Water Management District permit for the 7-Eleven.
Okay. So that's already been done, consistent with the ERP?
Correct. In the ERP shows that as the TOA slope for fill of that wetland area.
Okay, thank you.
Okay.
And then do you know on the Daniels buffer, does it match the one, if the 7-Eleven's already in for the DO? Do you know if it's consistent all the way across?
It should be, yes. It's the standard required 15-foot type D. So yes, it should be consistent.
Okay, that was it, thank you.
Mm-hmm. Can you bump it to slide 11? One more. So we just wanted to put up the graphic image that was submitted regarding stormwater management. As you mentioned, and we were just discussing, there is an approved ERP on the parcel. However, I want to be clear that that will be amended to reflect this development layout once the zoning is approved. The ERP includes the 7-Eleven tract with their proposed development and our lot, and we will do an amendment to reflect what's shown here. And as Paul indicated, the limits of the master concept plan and the wetland preservation reflect that ERP. And it's my understanding, and feel free to jump in if I get this incorrect, but that outfall is established in the northwest corner, and that will be maintained through our amendment process. There's no proposal to move that or anything else. Next slide should be Mr. Treesh. So Ted will talk about the transportation associated with the project, and he can also answer your questions about the controlled access resolution.
Thank you. Good morning.
Good morning. Ted Treesh with TR Transportation Consultants. We conducted the transportation analysis. Is this not working? There we go. The TIS that was submitted was done consistent with the administrative codes that is adopted by the county for the zoning. The TIS was done based on the worst case analysis that's included in terms of the schedule uses. Even though this is for a DollarTree, that's what's going to be submitted as part of the development order. The TIS was based on a fast food restaurant and a coffee shop, both without drive-through, since we do not have a drive-through use listed on the schedule uses. So the trip generation that we've analyzed is much more intense than what actually will be developed on the site. A DollarTree is a dollar store type use. Variety store is what ITE refers to it as, generates much less in terms of peak hour trips than what we've analyzed. So we've analyzed a much higher intense use at this zoning stage, which is what the county requires in terms of analyze at the zoning stage of the analysis. So that's what we've completed as part of this analysis. As indicated by Tina, the access for this property is being provided by the adjacent 7-Eleven parcel, which I was involved with throughout the process working with 7-Eleven. That, as Tina indicated, that development order has been approved. They're right now waiting on, I believe, through the building permits, speaking with the client on that parcel. That project is anticipated to begin construction here anytime. They're just waiting on a few permits in the building department before they begin construction. They have all their development order permits approved. They're just waiting on final permitting in the building department. We worked with the county in modifying the Daniels Parkway resolution to create this right-in, right-out access along the frontage of this subject parcel. The reason it was put on this parcel was due to the distance requirements on the access spacing along Daniels. There was an existing access on the Daniels Parkway resolution further to the west. If I could go back to the aerial, let's see if we have a better. There was an approved access resolution over approximately in this location on the resolution, and this property is heavily inundated with preserve and wetlands, and most of it's not developable. So working with the DOT staff, we work with staff and move the access to this location, and that's why the condition was put in the controlled access resolution that states that if and when this access is this property is ever developed and they want to utilize this access, which we don't think that will ever happen just because of the preserve that's already on this property to our west and the limited amount of developable land that's left over, that this access has to be removed and then a connection will be made and that frontage road basically extended to connect to that access. So that's how that condition came about in the resolution.
Well, and Mr. Trees, that
Yes.
significant wetland there is actually owned by the county, isn't it?
That's correct. Yeah, it's owned by the county. But there is a small sliver that is privately owned that fronts Daniels. But again, it's probably not developable in terms of what's left. So this bullet here shows what the language in the resolution actually states, that if the access at Station 2461 is ever approved, that the driveway that's on our subject property will be required to be eliminated at that time. And so,
Just to clarify, I'm sorry, so
Yes.
Station 2461 is the adjacent conservation property, and Station 2457 is this property?
2457 is the property to our west, I'm sorry. 2461 is ours, is our access.
Okay.
And the resolution 210506 was the resolution that adopted the relocation or the temporary access on our site. And that resolution has now been amended twice, most recently just yesterday.
But they all have that same elimination condition?
Yes, those carry through, and so the new resolution that was adopted Wednesday will have a new number, so they haven't assigned that yet, so it should be up on the website probably in a week or so with the new resolution. Right now, I'm not sure what the,
But if that happens, whose responsibility is it then to close this, the one that would be at this parcel, and move it? I would assume it would be the newest person in, right? Whoever would be developing that adjacent property?
yes,
Okay, so the argument is that the condition's not required on this zoning because it's already a condition of the controlled access
Yes.
or resolution, and it wouldn't be incumbent on your client to do that.
yes. Whoever constructs the access at that station will be required to close the right and right out at this station and meet this condition.
Okay.
And I don't know if you've seen the site plan with the 7-Eleven and our site together, but basically the frontage road or the connection runs through the 7-Eleven and then connects to Rickenbacker.
That was one of my questions. Hold on one second, if you can help me with that. So I found that under attachment I was the cross-access easement. That's what I'm relying on. So it showed, and I'll show you, so it had this sketch that essentially has it cutting through in that fashion.
Yeah, and I have a development work plan if you want to see it.
Well, it also had this behind it. I'm not sure if this is part of the easement area, but it seemed to show this would be the
Yes.
subject property, and then it looks to be in the same, so you're tracking the access
Yes.
easement as it was recorded?
That's
Okay.
correct.
So the intention is that traffic would connect from Rickenbacker through 7-Eleven to this piece and then back
Yes.
down to Daniels? Okay.
But we anticipate our primary access, again, will be off of Daniels, with the right in, right out off of Daniels. And again, a dollar store is a very low traffic generator if you've visited those stores, such as DollarTree, Dollar General. They're not heavy traffic generators in terms of peak hour trips.
Well, and Mr. Trees, let me ask you about that. It's my understanding that the peak hour that's of concern here is the AM, is that correct? That the higher number of cars on the road is, on Daniels, is the AM peak hour.
Actually, the higher in Daniels is the PM, but the worst condition in this case is the AM because that's the heavier in the east or the westbound
Right,
direction.
that's what-
Yes, that's correct.
So, and if the Dollar Tree doesn't open till 10, will it have any impact on the AM peak hour?
No, if they're not open till 10. Just the only people coming in would be staff in the morning.
And to your point about the trip generation, is it because mostly it's a pass-by trip?
Correct, yes.
Going back to the access road for a second, so 7-Eleven's in for the DO, they're waiting for the development permit. Are they going to be constructing this portion of the access?
That's correct.
7-Eleven will be doing that before the dollar store, whatever gets developed here, even comes in?
That's correct.
Okay. Thank you.
And if for some reason 7-Eleven were to be delayed and we were to come, and the Dollar Tree were to come in first, then we would construct the access to Daniels. But we don't anticipate that happening. Again, discussions with them just as early as last Friday. They're ready to go. They're just waiting on these final building permits to be released from the county.
If you were to come in first, if this property were to come in first, would you be responsible for constructing the temporary access road for the entirety up to Rickenbacker, or you would only be doing it from Daniels to your site?
We would have to work that out with 7-Eleven, but I would anticipate they would also want to get access to Rickenbacker's, but we would have to work that out with 7-Eleven to construct something through their property. But I would think they would want to get access to Rickenbacker as well.
Okay.
But again, I don't anticipate that happening based on where we're at right now. And again, the analysis showed, again, with the worst case in terms of what we conducted right now, that Daniels was shown with the project at a level service staff in the morning. That's when the heaviest traffic is westbound in the morning, but a level service C in the evening peak hour. And again, as Ms. Montgomery pointed out, the DollarTree isn't projected to open until 10 in the morning. So with this project, we don't anticipate any AM peak hour impacts once it's open. But right now, Daniels we're only 49 trips from the level service threshold in the morning. So it's teetering on the level service threshold brink right now. But we do anticipate some relief coming to Daniels, working with DOT. Lee County is getting ready to start the Alico Road Connector. You've probably heard of that in the news and seen other testimony on that. The Alico Road Connector is going to connect to State Route 82, and that's anticipated to provide some relief to Daniels. Right now, the Lehigh traffic only has one route as you come west to get into Fort Myers. Daniels is that first connection. Once Alico connects, that'll provide another connection before getting to Daniels, so that's going to provide a little bit of relief to Daniels for those Lehigh folks that are coming to work in the morning. So we do, the Lee County DOT does anticipate quite a bit of relief happening to Daniels once that Alico connector opens up, to allow those Lehigh folks that are coming to be able to access southern Lee County without having to come to Daniels to get to the I-75 corridor. Daniels, the turn lanes that are being constructed once with the DO that 7-Eleven is being done, those are all being completed by 7-Eleven. But again, with the development order, with the DollarTree, we'll have to evaluate turn lanes again at the development order stage, but we don't anticipate any additional turn lane improvements will be done at the development order stage. 7-Eleven is constructing all the turn lanes that'll be needed for the project. With their development order, they're constructing the right turn lane on Daniels Parkway as part of the right turn lane with that new access that's being constructed. So with that, this application meets all the goals and objectives of the Lee Plan and the Land Development Code in terms of transportation, and I'd be more than happy to answer any additional questions.
I think I asked them all as we went through, and Ms. Montgomery asked you the other one that I hadn't yet, so I believe we are set on that. Thank you.
Okay, thank you.
Do you want to go through the last two slides first, or do you want answers to some of the questions you had prior to?
You can complete if you're.
Okay. Okay. So really just for a high level at the record, I wanted to talk about Lee Plan consistency. I think it's fairly clear that this parcel has been platted for development and meets the requirements of the future land use category in placing existing commercial uses within an existing subdivision. We're obviously promoting compact and continuous growth consistent with Goal 2 and its appropriate standards. We've talked about the fact that all the urban services are available, and that the preservation is previously platted, and we do have an environmental resources permit, so the general development standards of Goal 4 have also been met. With regard to commercial development in Goal 6, there are a number of policies regarding how to ensure commercial development is consistent and compatible with surrounding development when we're talking about new and greenfield development. This is kind of what I would describe as a hybrid. We are in an existing commercial subdivision. It is appropriate for us to place a commercial use within that subdivision and not continue to push development further into greenfield locations. From that perspective, we do have appropriate access, as you heard from Mr. Treesh. The schedule of uses has been created from the underlying zoning districts, which is consistent with the adjacent conventional zoning on other properties. As we talked about, we do have the necessary buffers and open space, ensuring that the proposed variety store will be consistent and compatible with the adjacent industrial as well as commercial. And again, we've talked about infill on an existing platted lot. With regard to the findings that you have to make in evaluating the proposed request and sending a recommendation to the Board of County Commissioners, we have met the code to the maximum extent possible. The deviation request is appropriate and is consistent with the language of the Land Development Code, and the conditions that have been proposed by staff appropriately address the request. The proposed variety store is compatible with the approved 7-Eleven as well as the strip commercial and Norman Love, as we've discussed. The uses that could occur on the site through the schedule, should for some reason the variety store not go in, are also appropriate. And there is a process for Lee County staff to evaluate that new use through an administrative amendment to maintain that compatibility. As we've talked at length about the transportation access and that future access point, which will promote internal capture of trips and not push the burden onto Daniels Parkway. We've talked about the existing natural resources and the plat preserving just under 28 acres of the existing wetlands. That will continue. I will note, as it relates to your question, the Alta survey does indicate that there is some sort of preservation easement. It gives an OR book and page. I have not been able to pull that as I'm sitting here. So in answer to your question, there is something. I'm just not able to tell you exactly what it says in this moment. And then again, the use is an appropriate location, giving the proposed future access and then also the pass by of the adjacent arterial road. And so it is my professional opinion that you can make a finding that their plan development request today is appropriate and could make a recommendation of approval to the Board of County Commissioners. I'm happy to answer additional questions, but that does conclude the main portion of our presentation. I do want to circle back to the buffer question. 10416 and the table of required buffers indicates that when commercial is adjacent to PRE is the acronym, public preservation lands, no buffer is required. So I think the master concept plan is consistent with that table, and we may just need to have a discussion with environmental staff if there's some future question. And I don't know if Sharon would feel differently. Maybe we could take a break and sort that out before the end of the hearing. There is space there. It's just obviously not labeled for that reason.
With respect to the uses, it looked like staff had struck through a few. I just wanted to confirm that the applicant was okay with those.
That's correct. We have no objections to those changes.
Okay. That was the extent of my questions for now. Thank you.
Okay.
Whenever staff is ready.
Yes, ma'am.
Good morning.
Good morning. Sharon Badamchian from Lee County Zoning. My residence on file, I was recognized as expert in zoning and land use issues. I would like to be recognized as such at this time.
Yes, thank you.
Thank you. Well, as you heard, the request is to rezone 1.8 acres from different commercial zonings, commercial tourist and general commercial, to commercial plan development. The request is for 10,000 square feet of commercial building. And they are located in the trade port, future land use designation. And you had a question about those two preserve areas. They are recorded as preserve and plat book 48 page 3. They are not supposed to be developed. And we discussed about the access. Yeah, the access is going to be through 7-Eleven. And that easement document that I have attached to the staff report, there's one page that you had a question about it. That is actually is not part of the easement document. It is from 7-Eleven's development order plan. I should have labeled it differently. That's to show you that they are showing the easement, access easement to the site. They are requesting one deviation. Staff recommends approval, and I'm not even sure that they really need that deviation. It's a dry detention. And we usually do this 50-foot for wet retention areas. But regardless, staff has no problem with that. The uses, yeah, I removed some of the uses. I think those uses, it was kind of typo because it just didn't make any sense. I read several times. It's like, and they have no problem with that. Changes to development regulations, yeah, staff has no issues with that. And removing condition 3, the transportation, it's already in the resolution. So staff has no objection to the removal of that deviation. And with that said, they are in full compliance with all applicable goals, policies, and objectives of LEAP plan and the Land Development Code. Staff recommends approval subject to staff conditions, with the exception of the transportation.
The only other question I had on that same environmental memo, it seemed to say staff recommended the following condition about open space, but then there wasn't a condition about open space. It acknowledged that it was 20% and that they had provided 20%, so I don't think a condition's necessary, but.
I know there's no condition,
Okay.
it's just.
Just wanted to be sure we had dotted that I and crossed the T. Okay, and when you reviewed the proposed schedule of uses, because it already has the bifurcated commercial zoning, is there an intensification of commercial uses that's happening by this schedule, or is it
Not really.
identifying what's already permitted?
The existing commercial zonings are more intensive than what they are proposing, really. You know, before I forget, I have the affidavit of publications. They assured me it's for this project. I cannot read, but
Okay, let's make sure that this is for the correct case. They do make it rather small.
yeah, that's the thing. It's hard to read.
I do not think this is for this case, actually. This has a February 12th date, from what I can tell. Unless somebody else can read this farther down, it is very small. There's several cases, I
There are
guess.
several cases grouped together.
We'll need to confirm that, though. I can't
Yeah.
just accept something that we can't read and say that it meets legal muster. So,
I tried hard. I just couldn't read.
well, we can leave the record open to address that. It's just, I can't either without some benefit of
Maybe
the ability
you
to.
guys have
Give it a
better
shot, but
eyesight.
I don't know that my eyesight's any better.
He wants to try. Otherwise, we'll just leave the record open to provide that, because we do need to make sure that that's been addressed.
If your case is
Oh, my goodness. Oh, good Lord.
Yes. Even with my progressive lens focus, I cannot do that. Okay, well, we'll leave that.
Okay,
We'll
no.
put a pin in that for now, but I don't want to make our public wait for this. So thank you. Did that conclude your comments?
That concludes my.
Take a picture of it and see if you can expand it.
That's another, or absent some kind of a magnifying glass. Okay, we'll come back to that. Did applicant have any questions of staff before we continue?
No, thank you.
Okay, thank you. Okay, so with that, we will open the public comment period. So at this time, Mr. Owens, if you wanted to come forward.
I don't think it's right.
Good morning, how are you?
Very good, how are you?
Good, thank you for coming today.
Appreciate that. Mr. Chair, this is limited power of attorneys from pretty much everyone in the park.
Okay, thank you.
Can I-
Dogwood, Sequoia Development.
You need a copy of that.
Let's see, Andy from Ajax Paving, he couldn't make it.
I'm sorry, I can't hear you.
Yes.
But I need to know what you're handing her, and I can't hear
Limited
you.
power of attorneys from the property owners inside the park.
Okay.
So I have power of attorney from this development here, all these properties, and everyone in the back. He actually is stuck on I-75. So basically, 90% of the park. And as I told the young lady when I came in, I am actually the president of the industrial park
Okay.
as well. So we would like to just, number one, begin to address what's going on. We obviously have no problem with anything being developed. The park feels that the DollarTree is inconsistent with the industrial park. And with respect to that, you did bring up Norman Love Confections. Norman Love Confections, we actually had to, probably about 15 years ago, this park is under the Airport Trade and Commerce District, and I didn't hear that mentioned once. It is bifurcated by multiple different zoning requirements, but there is an overlay inside the Lee plan that talks about being able to put retail in this industrial park because it's inconsistent with the Airport Trade Commerce District. We actually, to get Norman Love and our allowable space, we were required to do a commercial plan development about 15 years ago that had a minimum, the county staff put a minimum of 10 acres that we had to do. And at that time, I possessed, I think, 13 acres in the park. So we did that. My business partner is Norman Love. I'll be straight up with that. We own the buildings up front. So that's how we were able to do the retail. We had to spend about $100,000 and spend about 2 years with county staff to get it approved. She is correct. Most of Norman Love's facility is production, and it's a manufacturing facility. He makes confectionaries, and he also makes pastries and other things, and he ships them out internationally from the airport. So that's kind of where we're at with that. I just don't see this as being consistent. I talked with the 7-Eleven folks. They approached the industrial park. We have a board. There are 3 of us on the board, myself, Andy DeCrane from Ajax Paving, and Keith Benasiak from Waste Pro. They approached us. They went through the process with us. This is the first time we've heard from DollarTree ever. So we all received our letters. I don't know why they came so late. You might want to look into that. We received our letters last Thursday, so I had to scramble to get everyone's ability to come to speak to you. Understanding that, we don't believe it's consistent with the overall outlay of what we're trying to accomplish here. Because if you take a look at who's in the park outside of Norman Love, we all fit the Airport Commerce Trade. ASI Signaling is the building over there. They are a infrastructure construction company. The one that's next to that, although it's called Sequoia Development, that is actually Jackson Pools, and they are a construction company, and they do commercial and residential pools. Then you have Richard Larson, or Larson Investments. He is a high-end RV storage, and he's about to complete his there as well. And then next to that, you have Ajax Paving, which is a major infrastructure company, and I have a point for this. And then in the back, every single parcel back in the back is owned by Waste Pro, which obviously we know what they do. I don't know how the TIS study took into, aside from the usage problem we have, We don't understand how someone even looked at the private road of Rickenbacker to understand the impact of all the heavy trucks that move up and down Rickenbacker, because we're talking AM and PM. Waste Pro runs constantly, as does Jackson Pools, as does Ajax, moving 18-wheelers, as does ASI with their deliveries that come in and out. In the morning at times in the AM, Waste Pro will have maybe 16 to 20 trucks waiting to either turn right or left onto Daniels Parkway. I foresee a problem happening at the choke point of our private road where it meets Daniels. So I don't understand how they did the traffic count coming out of the park. I get how they do it on Daniels, but so that's just basically some of the consideration. There's already 1 or 2 accidents a week at that intersection because people are trying to jump across the road to go east into Lehigh Acres or go west into Fort Myers. It's an absolute devastating intersection. So at that point, I would believe if we're going to go to a retail use, as do the rest of the park, we would request a signalized intersection or not bring a retail use into the park.
Okay, so I just want to clarify. So the objection is not to commercial, it's to the commercial?
No, it's inconsistent with what we're trying to accomplish. I mean, if you look at everybody that's in there, and actually Norman Love would have expanded had there been more property. He's actually moved a large portion of his business into the industrial park out in Gateway. Because, we could have purchased that property, 15 years ago and built whatever we wanted on it. It's been vacant for a long time, and I do believe it's been vacant for a long time because of the Airport Commerce Trade Park and the inconsistency. Everybody believes it's frontage on Daniel, so it must mean retail. So, but if you look at the Airport Commerce Trade District inside the Lee plan, it's inconsistent.
And when you reference the park, back to my question earlier, that it seems to be platted together, but there isn't a holistic unified ownership entity, a PD or any kind of unified zoning through this. So is that a board that you've self-created from the owner?
No, actually, the board was created by Don. It was, I think, his last name was Francisco. This is going back 30 years.
So it was a prior owner or whoever
Juan
platted?
Francisco?
Ron Francisco, yeah. Ron Francisco platted the park. And there is, in fact, excuse me, the two parcels here, the wetlands parcels, that is specific to, we actually have to maintain it as the industrial park. We maintain the drainage, we maintain everything. We also maintain our private roads. And if you want water and sewer, you have to have your own private lift station, and you have to bring in your own water as well. So the park basically stands alone on the property owners, and there really hasn't been much changeover in the park for the last decade. Everybody's been, they've owned the pieces that are in there.
So the ERP, the South Florida Water Management District Environmental Resource Permit that they were talking about that covers the preserve areas and the drainage, is that something that your board?
Yes, we actually received a notice of noncompliance because we didn't know that there was a certain part of, if you see our documents, they're thick. We did not know we were responsible, but somebody from Swift Mud was out there, called us in, and actually it was wonderful to have Waste Pro and Ajax there. They stepped in and they took care of it, and we did exactly what they asked us to do. So it is maintained by the industrial park, and I would have to check with my engineer if the calculation can include the wetlands in the calculation of how much can be determined to be retail. Because what we were explained in the beginning, and it was a 2-year process, that we were required to have a CPD of a minimum of 10 acres prior to move forward to get the retail platted in the front on Daniels. And I do believe 7-Eleven is consistent with the Airport Commerce District. I just don't think the DollarTree is.
Thank you. Thank you for coming today.
No problem. They forced me.
I just have a couple questions.
Sure, absolutely.
I'm assuming you're not testifying as an expert in.
No. I'm testifying as a 25-year landowner.
Okay,
in
you're not
commercial.
testifying as an expert in
No,
transportation.
no.
Okay.
I'm just
That's all.
speaking on behalf of the industrial park.
Thank you.
Thank you.
If I do next time need to bring an expert, I can bring our engineers and,
Well, after today's hearing, I'll make a recommendation that goes to the board, so there's a
Okay.
final hearing before them, but you have to speak at this hearing in order to speak at that hearing.
that's what I was informed. And they also informed me to bring those as well. to
Thank
make
you, and I
sure.
did accept these for the record. Thank you.
Great.
Thank you for coming today, sir.
And you might, this will answer that other question I'm getting, or the sub-biz of the industrial park.
Okay.
This is the ownership of the industrial park.
Okay,
And that is me,
okay,
and then the rest of the guys are on the other side.
okay. Thank you, and thank you for clarifying that information. Okay. Do we need to take a break before we come back to the
I don't think
applicant?
so. We wrote notes.
Yes.
I want to hand you another copy of the affidavit of publication.
Okay,
This one is clear, you can clearly read, and the cases here, installation is here at the bottom.
this one is legible. Excellent, thank you. Okay, yes, this one I can accept. So this will be Staff Exhibit 2. Staff Exhibit 1 was the staff report. Give me one moment to mark this. Okay, thank you.
So just to kind of address some of the statements that were made regarding the Lee plan and consistency with the airport and the trade port future land use. First, I want to note that I appreciate the process that was in place in 2010, 15 years ago. However, since that time, the trade port category has been amended multiple times. And looking at the Lee plan here, since 2010, it's been amended at least 4 times. And so I would agree that at one point in time, there were certain minimums for plan developments within the comprehensive plan. However, the policy as it exists today indicates that while yes, a plan development is necessary, the standalone retail calculation for commercial is 1 acre out of every 10 trade port or preserved wetland acres within the project. And so that amendment was made at some point between today and 2010, and we've kind of walked through this project's consistency with that policy through the demonstration of the subdivision. With regard to the uses and what is happening where within the subdivision, I would absolutely agree that everything north of the parcel that is subject to the application today and the strip plaza and even the Norman Love, while it's within an industrial zoning category, really the more intensive industrial uses occur to the north, appropriately so within that IG conventional zoning district, and or we can see plan developments have been filed and approved. And so what's happening is we're seeing the development come in consistent with the zoning map. And the request for a DollarTree is not inconsistent with the trade port future land use. Commercial is allowed. The schedule of uses has been created from the underlying general commercial conventional zoning district, which is on the property currently. It's on the property next door currently. And so there's not an inherent inconsistency there. It is appropriate. We did try to use the existing conditions to craft this plan development that is before you today. I understand the perspective regarding the traffic. You have Mr. Trish's testimony regarding how that was calculated, his traffic impact statement, and the supplement. With regard to the signalization that has been discussed, and that would necessitate a separate agreement, a 1.8 acre parcel and their traffic, while it may trip a threshold, is not the only use utilizing that intersection. And so that improvement would need to occur with the assistance of all of the owners within the subdivision as well as Lee County. There are mechanisms by which that can be accomplished at the point that the various thresholds have been met for a signalization. With regard to the water management district, the deeds and covenants do indicate that the common areas and the stormwater management is to be maintained by the POA. With regard to the fact that we have not gone to them regarding our architectural renderings and such, it's not that we are trying to skirt that issue. We were trying to get through this process first to make sure that we could have the building and then design it and work through those standards. So I appreciate that other property owners have taken a different process and approach. That was our approach, and we will certainly do better in communicating moving forward.
Does the LDC have a definition of compatibility? The gentleman talked about compatibility a lot.
It does. If I recall correctly, it's about not having negative impacts to the adjacent owners or alternatively being neutral. And so I think that this proposed development would fall into the neutral category. It's no different than, the strip plaza that already exists. There's going to be people that pass by Daniels Parkway that pull in that maybe that wasn't their destination originally. The same thing with the 7-Eleven. So that's not inconsistent with the other uses that we're seeing. There are requirements within Chapter 10 that address that compatibility regarding separation, setbacks, buffering, et cetera. And again, we used the underlying zoning to craft all that so that we weren't overdeveloping the property or reducing setbacks in a non-compatible way.
Okay, I just want to clarify something because I think the gentleman merged two different future land use categories. When the future land use map was created, these areas were, I believe, designated airport commerce. That was the predecessor category, and it had different requirements than the trade port. So, in your professional opinion, are the requirements of airport commerce, which no longer exist, relevant to today's discussion?
No, that category does not apply to this property or the subdivision as a whole any longer. So we can see that the future land use map is now fully trade port for the entire subdivision and wetlands. So the answer to your question is no, that would not apply.
Okay, thank you.
In the trade port category, in 1.13, they do talk about any kind of commercial standalone needing to complement surrounding businesses and industrial uses, and there was some discussion of that in your narrative, but could you expand on that a little more today, just how this particular use satisfies policy 1.1.13?
Yeah, let me pull the narrative so I'm not, I can't find the exact reference to read it, but I'll try to summarize, and then if there's more questions or I didn't hit it right, you can ask me to revisit. But so when we talk about commercial complementing industrial, we can conceptualize that in a couple of different ways. It could be an administrative office supporting an industrial warehouse. But I think what we're talking about here when we consider the underlying zoning and the intent of the future land use and the zoning coming together, we're talking about retail services that can support the employees and the customers of the industrial district, right? And so perhaps I'm an employee of one of these other industrial uses and I need some sort of something on the way home. So in the case of a DollarTree, maybe it's paper towels and cleaning products. I'm actually going to be able to service that need within an extremely close proximity to my place of employment with this use being within this subdivision, rather than getting on Daniels Parkway and going to one of the other commercial subdivisions to the east and the west. So we're also addressing that internal capture that Ted talked about earlier as well. And so I think it is appropriate. It provides a different type of use, a different type of retail use within this subdivision that can be supported by the employees, but also by the general public passing by on Daniels Parkway.
Well, Ms. Eckblad, let me ask you a question. Is there any difference between how the DollarTree would serve the area than the sales of commodities in 7-Eleven or Fine Folk Pizza?
I don't think so, no.
Is this more compatible than the med spa in the center?
I'm not familiar with the med spa, so I'm going to say they're the same. They're both commercial. They both provide goods and services. So from that perspective, I'm going to say they're the same.
Okay, thank you.
And can I just clarify, there was concern about Rickenbacker. I think I heard, and you might want Mr. Treesh to address it again, but I thought I heard him say that the anticipation is for this project that the traffic would be coming from Daniel, since it'll have the direct touch point, and that the 7-Eleven might have some through traffic through this parcel from Rickenbacker, but it would be unlikely that people would make the turn before
I'm
to get
gonna
to
let
Rickenbacker.
Ted
If you
cover
could
this.
just go through circulation a little bit, yes, just to understand what that looks like.
Can you walk through the traffic circulation? Because I'll butcher it, so.
Yeah, what was your question again?
The concern that we heard was that what impact this would have with Rickenbacker and the impacts and the interference with traffic that's already happening for the industrial uses that are further into the park. And so my question is I thought I heard you say earlier that even though this will connect to Rickenbacker through the 7-Eleven parcel, that your expectation and your analysis when you did the TIS review was that most of the traffic would be coming directly from Daniel, since you're going to be having the direct connection.
Yes, I mean, because we're on this parcel here, we anticipate most of our trips, the right in, right out, using the right in, right out. Obviously, because Rickenbacker has a full median opening, there will be some trips that if you want to go to the east, you'll have to come, if you want to turn left, you can do that here. But during peak hours, it is, as indicated, difficult to do that. You have the opportunity also to do a right turn and come down here to Chamberlain and do a U-turn at the signal. There's a traffic signal just to our west at Chamberlain, the old airport entrance, to do a U-turn, which people can do. Some people find that more easy to do during the peak hours rather than wait and try to do a left out onto Daniels during those peak times. But we have had discussions, we actually had discussions with the county when we were doing the 7-Eleven about a potential traffic light at that intersection. Once 7-Eleven gets in, I think those discussions will be probably accelerated with the county once that becomes operational. Because that facility obviously will generate more trips than a dollar store.
And the warrant, for the time of when that might be warranted to do the intersection analysis, that's something that would happen DO time or later, and then the
Yes.
county comes back?
Yes.
Okay.
And if the accidents are as the gentleman indicated, that's something the county needs to be, they do monitor their intersections, but if the accidents are occurring at that frequency, then the county needs to be made aware of that, because if it is becoming a health safety issue, then that's something they will look at, and they'll conduct their own warrant study and look at that.
Thank you.
Mhm.
Did the applicant have anything further on?
I just have a question. I know you usually do a site visit beforehand. Did you in this instance?
I did.
So did you have the opportunity to look at the industrial? Okay.
I got the lay of the land. I did.
What time did you go?
I'm sorry?
What time of the day did you?
I actually live, and this is off record, it's not something I live near there, so I'm by it frequently, so I've done several site visits for this case because it was convenient, so I've been all times of day, not night, but all times of day.
Thank you. We don't have anything else. Did you have any other questions?
I did not, we addressed everything. Did staff have anything final to say in rebuttal? Okay. Okay, so with that, we will conclude the hearing for today. As I said, I will be issuing a recommendation to the board, and so once that date is released with that information, Mr. Owens, you're welcome to come back at that point and speak before the board with the same concerns. Thank you, everyone, for coming today, and please stay well.